When you're trying to figure out the way in which Roman law evolves, it's a very long period of time. And probably the single most important break is the end of the Republic after the death of Caesar and the rise of Augustus, which spanned basically just before and just after the birth of Christ. And how does this influence things? And the answer is there are two ways in which you can look at this. One of them is a public law matter, and the other is as a private law matter. If you're dealing with the public law matter, the changes are very large. A Roman republic is res publica. It means that those affairs, the word res could either mean a tangible thing or a set of social affairs, which belong to the public, should be decided by the public as large. And so you see a very large role that's given to two classes. One, the Senate, which is a term we use for our upper house to this day, and then to the plebeians, which become the House of Representatives. And the theory was, representing individual groups in slightly different ways, there would be a clash and a set of checks and balances between these two parties, so that you could be reasonably confident that no one person could take charge. Much of Rome was governed by two consuls, not one. And so what you did is one executive could give a check against the other. And what you saw was a political system which obviously would have many weaknesses in practice, but at least was alert to the dangers of arbitrary power. And when you get to the empire, all of that starts to disappear. When it comes to the private law, the continuity across the Republican and the Empire is almost complete. If you go back and you start to read Gaius and so forth, what he does is he basically identifies two classes of scholars who differ from one another, the Sabinians and the Procleans, one of them being more concerned with substance and the other being more concerned with form as a way of organizing situations. And so what he then does is he presents essentially 20 or 30 disputes between the two schools on how it is these scholars would resolve problems. But essentially what happens is when you do Roman private law, you spend some time on the evolution of legal doctrines, but you don't pinpoint it or tie it to the political changes in the larger system. So the continuity between the time of the 12 tables and the time of Justinian is 1,000 years. On the private law subject, there's increasing sophistication, and they're major statutes. But again, the Lex Aquilia, which is thought to be the single most important statute on the law of torts, is adopted roughly around 287 BC, early in the Republic, and they're construing it for all it's worth 400 years later. Obviously, the change between the Republic and the Empire does not have much to do with what's going on in that very difficult statutory construction.